Hello again folks, welcome to the Supreme Court Historian YouTube channel. Once again, we are now going to discuss our first administrative law case decided on the 23rd of May 1951. This is the Supreme Court of India's judgment in the case known as In Re Delhi Laws Act. The In Re over here refers to the Latin phrase which translates to in the matter of. So in the matter of Delhi Laws Act, that is the name of this case. Why is it not someone versus someone else? Because it did not arrive at the Supreme Court in the form of appeal or some other original jurisdiction. This is part of the advisory jurisdiction of the Supreme Court under Article 143 of the Constitution. So we will look at that as well. I have given the title Validity of Delegated Legislation because that is what this case was all about. That is what the Supreme Court discussed in this particular judgment. Delegated legislation, is it valid? What is delegated legislation? What is in re? What is Article 143? All of these are part of our agenda for this set of videos. There will be at least 4, probably 5. I have not really figured it out yet because I simply do not want to make lengthy videos like the State of Tripura one, isn't it? The half an hour video. It's a bit ambitious to keep talking for half an hour without forgetting something. It is also a bit too much to expect somebody to listen for half an hour and remembering everything. So hence the split, just like we did with the A.K. Gopalan judgment back in our first set of videos. So in this video we will look at these constitutional doctrines, separation of powers and checks and balances. Then we will have another short discussion that will be dedicated to delegated legislation. Then another short video on Article 143 of the Constitution. This is the first case where this article came into consideration, and that is why it deserves its own video, I feel. And then we will look at the actual case, In Re Delhi Laws Act. So let's get on with it with the first item on our agenda, the constitutional doctrines of separation of powers and checks and balances. Theoretically, separation of powers is something that all of us understand quite intuitively, that there are 3 wings of government, that is the legislature, the executive and the judiciary, and these 3 are separate from each other. The theory being that if all of these powers are concentrated in one entity, in just one arm or just one king, an absolute monarch kind of a thing, then there is bound to be arbitrary use of these powers. There's bound to be tyranny and despotic rule. So the lawmaking powers are separated. In the case of our country, they are given to the parliament and the state legislatures. The executive powers are given to a different body, which is the Council of Ministers and all the officers that are employed under it. And the adjudicatory powers of government are restricted to the judiciary, the Supreme Court, the high courts below it, and then the subordinate courts in each state below each state's high court. So this is the separation of powers theory, that we should not concentrate all the powers of government in one single body. Instead, we should spread them out, and the demarcation is done based on the functionality. Is it a lawmaking power? Is it a law implementation power? Or is it a law interpretation power? That is basically these 3: legislature, executive and judiciary. In our constitution, however, this separation is not very strict. It is, some would criticize it as imperfect, some would call it flawed. I would call it non-dogmatic. It is exactly the way it should be, in my opinion. That just because there is a theory called separation of powers given by Montesquieu and everybody else, that does not mean that we are meant to follow it word by word. This is not some religious doctrine or something like that. This is something that we are figuring out for ourselves, and therefore we should not treat it as any dogma. Just as when we discuss the kinds of polity, and it becomes difficult when we want to classify India whether it is a federal or a unitary polity. It lies somewhere in between. Although we call India a union of states, we still have so many federal features in our constitution. So it lies somewhere in between. think of it in a similar manner, that the separation of powers in India is just like that, non-dogmatic. Instead, the doctrine of checks and balances is given greater importance in our constitution, and checks and balances is implemented with the same objective in mind, which is to prevent the administrative arbitrariness. I've given a couple of examples of checks and balances here. This is not a complete discussion at all, and it does not intend to be a complete discussion. Since we are mostly going to deal with the executive in this particular case in Re Delhi Laws Act, I have given two executive examples, that the executive is responsible to the legislature in our country. The legislature acts as a check on the executive, whether it is the Lok Sabha or the Vidhan Sabha in the states, in each individual state, right? The checks will be something like a cut motion or the question hour, or a confidence motion or no confidence motion, all of those things that are inherent in the powers of the parliament or of the state legislature. Another check on the executive is by the judiciary, when the judiciary can issue the various writs which we have discussed before, habeas corpus, quo warranto, and all of those, mandamus, prohibition, and certiorari. All of those 5 writs in the Articles 32 and 226 act as checks on executive action. So the separation of powers in India is a bit more arbitrary, and it is not at all distinct. It is not a strict demarcation. Each of the wings, the legislature, the judiciary, and the executive, each of them have certain powers that technically, theoretically, would not belong to them. For example, the legislature in India can behave as the judiciary. It can adjudicate itself when there is a question of breach of privilege. This is Article 105 and 194. We will arrive at cases that deal with these provisions, so I'm not going to discuss them right now over here, but this is just an example where the legislature acts as though it is an adjudicatory body. Another situation is the impeachment of the president, which the parliament is empowered to do, in which one house of parliament acts as the adjudicatory body, sits in judgment of the president if he has committed impeachable offenses, if he or she has committed offenses which would require the president to be impeached. That is an adjudicatory action, and that is carried out by the legislature, the parliament. Similarly, judges of the higher judiciary, High Court and Supreme Court, can be removed by parliament and by parliament alone. And over here as well, parliament acts as though it is the judiciary. So this is just one of the examples where the scope of the legislature has gone beyond that of purely legislation, but into judiciary as well. Does it work the other way around? Of course it does. Most of our videos deal with this situation where the judiciary has acted as the legislature, testing the validity of laws that have been passed by the parliament or by any of the state legislatures, and also testing the validity, the constitutionality, the virus of constitutional amendments as well. This can be done when we approach the higher judiciary, either through Article 226 for the high courts or Article 32, which is a fundamental right, to approach the Supreme Court. So this is an example of the judiciary acting as the legislature. Then of course the most common example of the judiciary acting as the legislature is Article 141, which is that the law declared by the Supreme Court shall be binding on all courts within the territory of India. So whenever any court is interpreting any law, that law has, if it has been already enunciated upon by the Supreme Court, then that law would be the law of the land, the law declared by the Supreme Court. So that is an example of purely legislative powers almost by the judiciary. Quite a few times the law leaves a lot of gaps that cannot be prophesied almost when the legislation is being created. Then those gaps need to be filled in the real world when a situation arises where the interpretation of the law needs to be done in order to decide what is the aspect of law that was intended by the legislature. All of this interpretation is done not by the legislature but instead by the judiciary. So another example of the judiciary acting as the legislature. Then there is the more technical aspect of the judiciary acting as a legislature, that is, it is empowered to do under Article 145. Subject to the provisions blah blah blah, the Supreme Court may from time to time make rules for regulating generally the practice and procedure of the court. There are so many rules and regulations that every body, every administrative governmental body requires for its smooth and seamless operation. Rules as to proceedings, rules as to court fees, for example. All of these are not legislated upon by the parliament or by the state legislatures. The courts decide for themselves, and this is an example of delegated legislation actually. But as far as our discussion at this early stage, it is another example of the judiciary acting as the legislature. The executive also acts as the judiciary on several occasions. I could give you a list for hours and hours together of the various judicial powers or quasi-judicial powers or quasi-judicial powers if you're American that are inherent in the various executive authorities in our country. Anybody who has had any interaction with any district magistrate will have plenty of tales to tell about the judicial powers of the said collector or district magistrate. Just an example of an executive authority holding some judicial or adjudicatory powers. Then there's of course the more noble powers given to the executive, which is the president or the governors of the various states under Article 72 and Article 161 respectively. The power to grant pardons and reprieves and commutations and all of those things, where a particular sentence is commuted or is held back or is excused or the person is entirely pardoned for any offenses that that person had committed. These powers basically of the judiciary are available only to the president and the governors, only to a particular person in the executive structure. So that is another example of the executive acting as the judiciary. And finally, there is of course the executive acting as the legislature, and the example for that is what is known as delegated legislation. What is delegated legislation and is it valid at all is what we will discuss in the next few videos. Hope you join me then. Thanks a lot. Bye bye.